Hello, and welcome to Fundamentals for Startups, a CoMotion Labs production. My name is Zach Chamberlain. I am the CoMotion Labs manager over at Fluke Hall for Life Sciences, and I'm your host today. If you've joined us before, you know that CoMotion Labs is a multi-industry incubator hosting early and stage startups from both inside and outside the UW community. We are committed to nurturing and enabling success for our startups, contributing to critical infrastructure, and developing opportunities for learning and mentoring and networking. We also do this without taking any equity or IP. We have 3 incubators, 2 locations on campus. One is over here. This is the Tech Startup Incubator. And then we have the Hardware Hall Incubator and the Life Science Incubator over at Fluke Hall. If you are a founder and you're looking for a community to help your startup grow, we'd love to talk to you. Fundamentals for Startups is a regular lecture series open to anyone interested in learning about entrepreneurship or building a startup. Every week we bring in experts with diverse perspectives and experiences to share insights, inspire action, and offer space for questions. A few announcements before we get started. All Fundamental Startups are presented and archived on YouTube on the CoMotion website, where you can filter by topic. If you learn about and register, or to learn about and register for future Fundamentals events, please visit CoMotion Labs online and subscribe to our YouTube channel. Today, I'm excited to introduce Ben Straughan and Steve Merrimen, partners at Perkins Cole LLP. Ben and Steve are attorneys in the Fintech space, and today they will talk about new reporting requirements related to the Federal Corporate Transparency Act and offer guidance for early stage entrepreneurs and their companies as they work to comply. Welcome, Ben and Steve. Thank you.
Thank you. Thank you, Zach. And we're very pleased to be here, and we always enjoy a chance to work with CoMotion and then to see what you're developing here at Startup Hall. I think as someone who's worked with startups for a number of years, it's just very exciting to see how the University of Washington, both the campus and the school and beyond, are coming together here at Startup Hall. So we're appreciative of that. And I'm going to do a little introduction and then turn to my partner, who will really go into some detail on the CTA. My practice, as I said, focuses on startups, so part of our emerging company venture capital group. So we help companies that get formed, raise early equity, venture capital, growth equity. We help them manage things like who owns the company, how do you manage stock options. We help with corporate governance and board meetings and kind of all the issues that come up with early stage companies. It's very important to be efficient in our practice. So we keep things as simple and straightforward as we can with our forms, kind of getting experienced people that get a lot of at-bats, doing it again and again, so we're able to answer questions quickly without spending a lot of time on research and things of that nature. And as a result, something like the Corporate Transparency Act, which it raises a specter of regulation for early stage companies, really catches our attention. And we just want to take a moment to explain a bit about the act, because my guess is people involved in the startup ecosystem, you are hearing some questions about it as well. So we'll give you some background, hopefully make it a little less confusing. And I'm sure over time, as we get more used to it, it will be less daunting, and this is the first step in that process. So with that, I'm going to turn it to my partner, Steve Merrimen.
Thanks, Ben. I'm Steve Merrimen. I'm a partner in our Fintech industry group, and I'll tell you just briefly what I do. The cool thing about my job is I help innovators launch emerging financial services and stand up compliance programs that are often needed to make growth sustainable. I practice a lot in the anti-money laundering and sanctions compliance space, which is why I'm here. So I'm excited to share a little bit about my world and hopefully give you sort of like a directional feedback on where you might want to go to help you issue spot and figure out what things you might need to do to comply with this act. to start, I'll just sort of highlight that this is a kind of complex law with a lot of different definitions and, candidly not a lot of guidance that is out there right now. So my goal here today is to tell you what the law is, why it exists, and help you issue spots so you can figure out when do I need to be thinking about this law, and what do I do about it. All right. So I want to ask a question to start. Has anyone ever heard of the Financial Crimes Enforcement Network before? 2 people, 3 people, all right. So this is a obscure government agency within Treasury that is charged with overseeing the act. And so it's this law, which is really an anti-money laundering law, is going to give a lot of people who've never heard of this agency before, get them familiar real quick. It's helpful I think, that anytime that you look at a law to think of first principles and to sort of understand why does this law exist, and so that helps you understand how will this law be interpreted going forward. Because this is a money laundering law, the goal here is to prevent money laundering, obviously. And if you think of what money laundering is, it's really intended to hide the source of funds or who's behind it in order to make the funds look legitimate. And so obviously one way that if you are trying to launder money is you try to take advantage of anonymity. And one way that bad actors have done that over the years is take advantage of the anonymity that is sometimes provided by corporations or LLCs or other sort of business structures. So this sort of issue kind of came into focus for the public, at least, with the Paradise Papers, with the Panama Papers, where you heard reports of people overseas setting up corporations in Panama or some other offshore island, and you actually, when you go trace the address behind the company, it's just really a placard on the wall somewhere in Panama. And then you look at the records, that there's this person who looks like they have no connection to the entity at all, is really just being paid to serve as a nominal director of the entity. And so, to sort of shine the light on the focus of anonymous companies and how those sort of shells were being used for illicit purposes. The initial focus was offshore jurisdictions, but in reality, a lot of those anonymous companies are actually formed here in the United States. And the reason is because when you form a company with the Secretary of State or register to do business, you're not really required to disclose who owns the company, and there's varying amounts of information that have to be disclosed about who operates the company. So if you're a bad actor, shell companies have been a vehicle that have been misused for purposes of money laundering, evading sanctions, all sorts of other illicit purposes. And this was, candidly seen, in the anti-money laundering space, this sort of shell company vulnerability in our laws was viewed as sort of a big red flag, because there are a whole bunch of other jurisdictions in the world that had already set up corporate databases of who owns companies, who controls companies, and the fact that the U.S., one of the largest sources of anonymous companies, had not. So in 2021, the Corporate Transparency Act was passed. In the last couple of years, FinCEN, the regulator that you've never heard of, but now you know of, has been working on regulations to stand up the requirement to require most legal entities to report who owns and controls those entities and keep them updated. The estimate is that ultimately 30 million companies will need to report to the federal government who's behind the company, who controls the company, who owns the company, and keep that information updated. And there are penalties both for the company if they violate the act by willfully not disclosing that information or keeping it updated, but also to senior officers or other gatekeepers to corporate formations have liability for violating the act. So the intent here is ultimately to shine the light behind shine light as to who is behind companies, and so to prevent misuse of entities. And the unfortunate thing is that obviously means that there's a new compliance requirement for startups to have to navigate. So here's the core of the reporting requirement that we're talking about. The Act requires reporting companies, and that's a defined term, and I'll kind of break that down as to what that means, to report to FinCEN information about their, quote, beneficial owners, and in some cases, their company applicants. Each of those are defined terms, and we'll get into this in more detail. And the second obligation is there's an obligation for reporting companies to file updated reports when the information that they previously provided changes. So you have a new senior officer, your ownership changes, in some cases, if you get a new driver's license and the number on your driver's license changes, you have to file an update. So let's start going through each of the defined terms in order. So the key term here is a reporting company. And reporting companies must provide information about, their beneficial owners, about the entity itself, and their company applicants. And the information includes things like the names of beneficial owners, the date of birth of beneficial owners, the address of where they live, and an image of a valid state license or a passport. So the obligation primarily falls on the reporting company to make that filing with FinCEN, but there's an alternative called filing, creating a FinCEN identifier and providing that information to the reporting company to then pass along to FinCEN. So in a typical scenario, you as a beneficial owner would have to collect your information, give it to the report, to your company that has the obligation to report, and then that company would provide that information to FinCEN. As an alternative to that process, you have the ability to create, essentially register directly with FinCEN by providing that same information, name, date of birth, address, ID, and get an identification number that you can pass along to any company that has to report your information. There are a couple benefits to that. From a data privacy perspective, there's for the individual, there's one entity that has that information, not two. So you have just the federal government and not the federal government plus that company. And second, for the company's perspective, it shifts the obligation to update that information to the individual. So if you're a company and you're thinking about how do I comply with the obligation to update it, update your reports, one way to sort of minimize your burden is to require anyone who has to be reported provide a FinCEN identifier and require them to keep that updated in lieu of taking in their personal information and potentially having to store it. The downside for individuals is it creates sort of an uncertain obligation to continually update that information directly with FinCEN when it changes. So for instance, there's no way to deregister yourself for the database, so theoretically there's an ongoing obligation to update that information regardless of whether you're a beneficial owner of a company or not. So there are pros and cons, but the general trend for companies in particular is to want their beneficial owners to give them a FinCEN ID. So the second question is, you have an obligation to report, when do you do it? Unfortunately, it's kind of confusing, and it depends on the date that your entity was created. So if you have an entity that was formed in 2014 and through the end of this year, you have 90 days to file a report with FinCEN, the initial beneficial owner report with FinCEN. If you file an entity after 2015, you only have 30 days.
25, 24, 25.
Yeah, so between January 1, 24 through December 31, 24, you have 90 days.
Okay.
If you file, again, on January 1st, 2025, you have 30 days. So there's a little bit of an extra grace period here because of the fact that this is a new law that just took effect in January. if you have an entity that was formed prior to this year, you have until the end of this year to file your initial report if it is a reporting company. One quirk is that if you file a new entity, you have to provide information about the beneficial owner and the company applicant. Again, we'll get into those terms later. But if this is an existing entity that was formed before this year, you don't have to go figure out who is the individual that formed your corporation or report that.
Steve?
Yeah.
Just one thing I'll say, and maybe some of you experienced this, because it went into effect January 1st, 24. What we found was we were rushing to file entities before then to buy a year for the company until 25, and they had to file. That's a kind of a moot point now, but it was one impact of the laws. If we thought someone even might need a corporation, sometimes we would form it so that it existed on January 1 and we had extra time, gave the company a year versus 90 days to file the information.
The second obligation is to file updated reports of beneficial ownership changes. So again, you have 30 days to make those updated reports. And to reiterate one thing I said previously, but if the beneficial owner provided their sort of ID to the reporting company, then the obligation to report falls on the individual, not on the company. I think it's sort of good practice to encourage, to make it clear to any beneficial owner that you expect them to make updated filings and to comply with that obligation as sort of a risk mitigation measure. But in general, the obligation in that instance is on the individual. What is a reporting company? So the law broadly describes a reporting company as any entity that is, any domestic entity that's created by filing a document with the Secretary of State or the tribal equivalent. The second category is a foreign entity that is registered to do business in a jurisdiction that has, and registered to do business by filing a document with the Secretary of State. The practical reality is that it's sort of any entity that is formed by filing a document with the Secretary of State falls within this initial definition, but what it doesn't include is entities that can be created without a filing. So for instance, a trust is is an arrangement that isn't created typically with a filing. It's created through a trust document. So I think for your purposes, the sort of thinking is, if you filed a document with the state creating the entity, you're going to be a reporting company unless there's an exception, and we'll get into those later. But that's sort of the one wrinkle, is that you're most likely going to start off as a reporting company. Because this is the law, there are an unfortunate number of exemptions. There's actually 23, and these are just some of them. But broadly, they are intended to carve out entities from the definition of a reporting company that are either regulated in one other way, so for instance, like a financial institution, or they are large enough that the risk of money laundering is sufficiently low that the government has made a decision that there's not an obligation to file a report. I'll kind of focus on two of them real quick, but the sort of basic principle is that these are intended to be sort of narrowly construed exemptions to the general obligation to file a report. So the guidance from the government has been that if you have questions about whether an exemption applies, you should err on the side of reporting. I'll call it sort of two quirks. There may be a scenario where you start off as quote unquote a reporting company and you have an obligation to file beneficial ownership reports with the government, but then you suddenly qualify for an exemption for one reason or another. For instance, you qualify for the large operating company exemption, or you are acquired by another entity that is exempt. you then sort of no longer have a reporting obligation, but that trigger of that exemption would trigger an obligation to tell the government, hey, I'm no longer a reporting company. And you have 30 days to do that because that's treated as an update to your previously filed information. The other challenge is that there may be scenarios where one year you qualify for an exemption, but the next year that you don't. And so you would then have to refile your beneficial ownership information within 30 days. So the practical reality is that, if you are taking advantage of an exemption from this reporting requirement, you should have in place reasonable procedures to sort of monitor to whether you are actually still qualifying for this exemption. So what we found in counseling companies is that they've sort of thought that, okay, I qualify for an exemption, I don't need to think about this at all. That's really not the case. It's this: if you qualify for an exemption, you need to monitor for whether you're always going to qualify for it. Here's sort of two, I'll walk through two exemptions that are most likely to come in play for startups at some point, or may come into play for startups at some point. And Ben will tell you why at the outset they're not likely to apply. There's an exemption from the definition of a reporting company for what are called large operating companies, and they're so essentially any entity that has more than 20 full-time employees in the U.S. That analysis of whether an entity has 20 employees can be tricky if you have a big corporate structure and you have one entity that is actually employing them and then leasing them to another one. But the sort of count happens on an entity-by-entity basis. The second is whether the entity has a U.S. operating presence that is effectively something more than a shared office space with a whole bunch of entities, or like a virtual office space, and has filed a tax return showing more than $5 million in gross receipts or sales in the prior year, excluding sources outside of the U.S. Of course, it's the law. There's a lot of weird caveats and wrinkles here. But this can be aggregated across entities if they file, for instance, a consolidated tax return.
Question, because I think, as Steve says, for startups, it's often very hard to meet these requirements. You're not going out of the gate. When you say 20 employees, a lot of times we'll talk about full-time equivalents, but they'll be contractors. So, would a contractor meet that requirement?
No, generally not. So it ties, there's the sort of nuance here is that it ties back to the IRS's definition of an employee. And sort of the intent is to limit it to employee relationships where the entity itself is directly employing the entity and not contracting with some other party for the entity services. So it's facts and circumstances may vary, but you need to be really sort of mindful of, okay, what actually is a full-time employee for this purpose. Do you want to talk about why a startup won't qualify?
Well, I think you've given a pretty good summary, but you need 20 full-time employees, you need $5 million in revenue, and then the virtual office point is another good one because many early stage companies are just virtual offices. So we generally assume that the early stage companies we're working with are not going to qualify under the large operating company.
And they wouldn't qualify for at least until they have actually filed a tax return.
Great point.
So, for instance, you may have on paper in your own books and records show that you've had $5 million worth of gross sales in a year, but the exemption wouldn't actually be triggered until you've actually filed a tax return with the government showing that. The second kind of key exemption is the subsidiaries of exempt entities. So there's an exemption for entities who are wholly owned by one other exempt entity. Sort of two key things to point out there is that has to be 100% owned or controlled by, well, sorry, let me rephrase that more precisely. The ownership interests have to be wholly owned or controlled by another exempt entity. So in practice, if you have an entity that is 75% owned by another entity that is exempt, but 25% owned by someone that is not, you are not, this exemption doesn't apply. So there are some wrinkles as to, some types of subsidiaries that can't take advantage of this potential exemption. So, money services businesses. So a lot of the companies that I work with, that's sort of my bread and butter, but they wouldn't be able to take advantage of, subsidiaries of one of my clients wouldn't be able to take advantage of this. So who's a beneficial owner? So, taking a step back and going to first principles, this isn't the idea is to capture broadly persons who can, generally control the ownership interest of a reporting company and anyone that exercises substantial control over the entity. So, two things to point out. Generally, certain senior officers are always going to be beneficial owners and always going to need to be reported. So for instance, the president, the chief financial officer, the CEO, the chief operating officer in general are going to be expected to be beneficial owners and therefore have to be reported. It wouldn't necessarily, the term senior officer wouldn't necessarily capture like a CTO because, you have a question?
Yes, there's a question from the live stream that says, is there minimum revenue exemption? An example is gross revenue less than $100,000.
A small company. If I'm understanding it right, is there a small company exemption because your revenue is so small?
There isn't. Unfortunately, you have to qualify for some other exemption. The sort of, if you go back to what is the goal behind this law, what the government has found and what researchers have found is that it's often sort of small shell companies that don't have any real operations that are being misused. And so it would, although I think there was some talk, at least initially, of having a small company exemption, that was pretty, that never came to fruition, I think, from the reasons that, hey, if there's this typology that we're trying to address, and there's an exemption that falls kind of squarely within it, sort of, unfortunately, renders the law fairly ineffective, unfortunately. So the sort of short answer is presume, I think, that you need to report until it's pretty clear that an exemption applies. So I think where I left off was that the CTO wouldn't necessarily be a beneficial owner because sort of they're not generally in charge of the operations or structure or the finances of the company, but they might be for other reasons. So these definitions are kind of confusing and sort of, but practically a functional test sort of look at what is the role that anyone within the organization has, what their rights and their abilities are to own or control the company. For ownership interests, there's a 25% threshold. So it's any individual who directly or indirectly, so through various other corporations or other legal entities, owns 25% or more of the ownership interests of the reporting company. Some quirks are that ownership is defined to include things like options or other rights to buy and share the shares of the company or legal interests of the company, even if they don't technically meet the equity percentage at this moment in time. So the takeaway there is you have to kind of look at what, if you have a complex structure, you have to really look closely at the facts and circumstances to figure out who falls who meets that 25% threshold.
Yeah, and I'll just say for startups, right, stock options in particular are frequently used, so you need to look at those as well for the beneficial ownership.
Yeah, and the direction from FinCEN is this, for purposes of calculating that percentage, it's actually to treat those options as if they've already been exercised. So the calculation can get kind of complicated pretty quickly, but the goal again is to protect against any sort of loophole that at a technical level could prevent, reporting. So it's intended to be construed very broadly and err on the side of disclosure. I do want to call out one thing here is that the term beneficial ownership covers interests held jointly. So in a state like Washington, where it's a community property state, you may have a scenario where, for instance, I am the owner, I have an equity interest in a company. On paper, I'm the person that directly owns it, but because it's a community property state, that's owned jointly with my wife. And so, this isn't in FAQs that FinCEN has published, but we've heard informally that the expectation is that when you have a community property interest, that both spouses would need to report as beneficial owners, not just the person who sort of directly acquired the interest. One sort of quirk is there's a pretty big ambiguity about whether board representation in and of itself makes you a beneficial owner. And our hope is that at a certain point there'll be more examples and guidance from FinCEN that talk about under what circumstances a board representation itself is enough to make you a beneficial owner. So the only guidance we've gotten is it depends. So, the unofficial sort of position that we have taken is that if you have a small board of directors of 4 or less, then then probably err on the side of reporting each individual director. But for instance, if you have a large board of a director and they each have, 7+, if they each have equal interests or authority over the company, then may not necessarily need to be reported. But you have to look out for things like, okay, does one have unequal voting rights or veto powers that might give them a modicum of control? So, that's something to pay attention to try and figure out who is your beneficial owner. You have another question?
Yes, another one from online that is asking, is reported information publicly available? I'm concerned that if people could see who is the beneficial owner, that could result in targeting for a variety of malicious activity.
It's not. It's a non-public database. So there are certain government agencies that can get access to it. For instance, law enforcement can get access to it in certain circumstances. Financial institutions, so for instance, your bank, may have the ability to get access to that information to verify who you are. Or who owns the company as part of their own legal obligations, if the reporting company agrees that the financial institution can access that information. Financial institution regulators can actually get it, but the too long didn't read version of this, that it's generally not, it's not at this point a public database. There are other jurisdictions in the world, and particularly in the EU, which is sort of surprising to me, where some of this information is public, but at this point, it's non-public information. The second key term, and we can kind of go over this quickly, is company applicant. So in addition to disclosing who the beneficial owner, if your entity was formed after January 1 of this year or was first registered to do business after January 1, you also have to disclose who your company applicants are. And you can put up to 2. So you're required to report, the person who literally pushed submit on the application, and you're also required to report, the individual who is primarily responsible for directing or controlling that filing. So in practice, if you use a corporation service provider like a CT Corp to make those corporate, the initial filing, that person who made that filing would be obligated to either provide you their information or provide you with a FinCEN ID that you could then include in the initial report with FinCEN. Yeah.
I'll just say this got our attention because, if our paralegal, so if you file a certificate of incorporation, that would be the most common thing with the state of Delaware, for example. Then if our paralegal files, they push the button with CT, are they directly filing, or is that if they have a registered agent file for them? You don't have to know the answer, but I would think we would err on the side of caution and include the paralegal.
I think it's going to depend. I think it's going to depend on. I think that's right. It's going to depend on whether. I think whether you're doing it through an automated system at CT Corp.
Yeah.
Or whether there's literally someone at CT Corp who is making that submission.
And we'll be sure and cover that piece of it, the automated piece. But the
right.
second, so you have, at least for us, one person who's potentially a reporting person, and then the second is the partner, so who is overseeing it, would be responsible. And I think a common theme Steve brings up is there's this update. There's the obligation to keep things updated and the like. So it's really important to be clear on who's undertaking filings or who's taking that responsibility on.
Yeah, that's a good point. Yeah.
Another question. I'm a part-time consultant, a one-person firm registered in Washington as an LLC. Sounds like this makes my company a reporting company, and both my wife and I are beneficial owners. Does that sound correct?
So, can you repeat that one more time?
Of course. I'm a part-time consultant, a one-person firm registered in Washington as an LLC. Sounds like this makes my company a reporting company, and both my wife and I are beneficial owners. Does that sound correct?
It does. So I think the scenario you're talking about is, you file, you created an LLC that you own. It's, unless, generally unless you qualify for some exemption, then you would probably be a reporting company.
Like in practical terms, like anyone who's an LLC in Washington has to file an annual report. And if you have like an attorney who does that for you, is this just going to become part of what, like if you're like recording the person who presses the button that submits this, it's just going to be submitted with the annual report by the person who probably files the annual report. It's just going to go somewhere else.
So, do you want to tackle that, how that works in practice? But this is technically a separate report that's in addition to what you file with the Secretary of State.
Yeah, I understand that,
Yeah.
but that's not often being filed by the person who leads the company. It's often being filed by an attorney on
Yeah.
behalf of the company. And this slide says that you have to report up to 2 people who might be actually doing the filing, and those 2 people would probably be your attorney, not you.
Or who's ever in charge. Maybe I'll jump in, because what's happening over the course of this year is some of the services. There's CARTA, which are people familiar with cap table management. There's CSC. There's a company called Single File that are gearing up to take on that responsibility. So I think the right answer to your question, as I think about it, is yes. It's all going to become pretty rote and managed as part of the annual filing process or reviewed, but there's still, there's some nuances on the need to update for changes. And
your annual report as well.
Yeah.
They're always asking. The annual report is always asking, like, have you had changes in your membership of your LLC? Like, even if it's like bringing someone new on or changing the percentages, which is completely aligned with what this is asking for.
That's a fair point. I think, I will say in my experience, we don't get overly fussed if that information is late, but we would be concerned, more concerned if the report to FinCEN wasn't timely updated. So I think it's just there will need to be more rigor on tracking and reporting those changes, maybe than a lot of companies have had in place.
Oh, you had a question. Okay.
Is the same update requirement for beneficial owners also applied to the contract signers, filers,
The company applicants?
the company applicant?
No. So the company does not have an obligation to update the
Okay.
company applicant's information.
Yeah, because
So-
that would seem weird if we
Yeah,
have to
like-
keep your paralegal's passport photo forever.
Yeah, that's right.
Okay.
That's right. So, I mean, they may have an obligation because what's in practice, what's probably going to happen is rather than Perkins Coie's paralegal sending you their passport information, it would give you a FinCEN ID, and then they would have an obligation on the back end to keep that information updated. I mentioned at the beginning that this law has some teeth, and so there's obligations that there's liability for the reporting company if they willfully don't file a beneficial report or they file false information with sort of willful blindness to its falseness. But there's also kind of gatekeeper liability provisions here. So there's potential liability for the senior officer of a reporting company for willfully filing, having the reporting company willfully file wrong information. And there's a broad provision for anyone who causes a violation of the CTA. So it's not just the liability itself isn't just necessarily on the reporting company or anyone that has the obligation to directly file with FinCEN. It's anyone sort of in the process of forming companies or would have a responsibility for overseeing, making sure that the information making sure that the corporation actually files the information that is required. So there's civil and there's potential criminal penalties, and there is, sort of helpfully that there's probably going to be a lot of scenarios where someone just inadvertently, because they don't know, doesn't file a CTA report or doesn't, forgets to file an updated report, and it's, those scenarios are unlikely to, in my mind, trigger liability. The focus is going to be mostly on scenarios that are sort of egregious violations where, in my mind, it looks like you're attempting to hide that information from the government. And because of how broad these provisions are, it's important to think about them and to proactively think about how you might comply. But it's focused. The liability is focused mostly on willful violations of the law. Just sort of a kind of a quick point. One point of emphasis for this law is on sort of this theory of gatekeeper liability, where essentially, you're responsible for the actions of a third party. And so, for instance, there's a significant emphasis on making sure that lawyers or trustees or accountants or corporate service providers or senior officers and directors take the obligations of the CT Act seriously, and sort of create some risk that those people need to proactively try and mitigate. All right. Here's the reporting process. So this is the initial reporting process. So here's sort of the waterfall of what do you do. Step one is obviously, all right, do you fall within the definition of a reporting company? And if the answer is yes, then you look to, okay, who are the beneficial owners that have an obligation to report to the government? And third is, once you figure that out, the question is, okay, do we have an obligation to report company applicants? And if so, who are they? And then next step is obviously gather the information that is required, or the FinCEN IDs of the people who need to be required, and then file that report with FinCEN. the way that you do, there's a couple ways that you can make that report. You can, the company can file it directly with FinCEN by filling out the form, or you can rely on a third-party service provider like a CARTA or a CT Corp, who will help you make that filing. To your point about for a fee, of course. So you can do it yourself. It hopefully should be pretty easy and straightforward to actually file the thing. The hard part may be, one, figuring out in some circumstances whose information needs to be reported. So that's the high level of the process, the nuts and bolts. And so any other questions, I'm happy to answer. That's a lot of sort of really technical in the weeds detail, but hopefully it helps you kind of issue spot on what are the things that you should be thinking about and when do you need to sort of dig in and look for further guidance.
Just in case this question comes up, from UW Startups, we've had this question arise of whether or not the University of Washington, as an equity holder, would rise to the level of needing to be a beneficial owner. For the majority, we don't hold that level of equity, and we don't have company control. So just in case anybody had that question, I just thought, say that we already looked into it. Always confirm with your attorney, but that's by reading the law and conversing with our counsel, that seems to be correct.
Yeah, I'd have that same reaction. It's usually a smaller than 25% threshold, and the University of Washington is not interested in having active control in the startup. So, yeah.
So you talked about the requirement to maintain the accuracy of the information with updates. I mean, is this something that just gets updated at the end of the year and you just catch up all of the changes that happened, or you're supposed to all right, I added somebody to the cap table, you're supposed to put an update in?
It's a real-time obligation to file an update. And so when that information changes, you have 30 days to make that filing. So, it's not something that you can do, on a sort of one-off basis at the end of the year to sort of catch up on what happened over the course of that year.
I guess that means you'd have to continuously ask yourself these questions, which obviously is impractical. People are just going to forget.
I think that's right, that it would be difficult to continuously ask yourself these questions. I mean, there are obvious transactions. You would think of a financing, right, or some kind of acquisition is when you would want to check, where there's significant shifts in ownership.
Yeah, I don't know which is worse, this has to get updated 5 times per year, or I never need an update, therefore when it actually is needed, I can't even remember this exists. Yeah. So either outcome is probably going to not happen.
Yeah, I don't have the complete answer other than you would be, relying on services. For example, with CARTA, they're tracking your equity ownership. There's at least some kind of trigger to.
Right, but this is role dependent, not just equity. That would work for the, shareholders, but there's a whole bunch of other conditionals that don't show up in CARTA.
Yep, that's a fair point.
So yeah, a recommendation back to them is shouldn't this just align with your annual reporting at the end of the year and things just get brought up to date? Because this is just going to be inaccurate almost all the time.
Mm-hmm. Yeah, it's an interesting idea. I don't think it's what the law says, but I take your point. It's what it should say, perhaps.
Has there been any sign of reduced company applications or LLC applications with the instatement of this law? And is there forecasting for reduced applications due to either these shell companies being not a functioning service anymore?
I haven't heard any of that.
No.
One way or the other.
I agree.
I realize that I have 2 more slides, and I'll just sort of briefly cover on some of the things that can make your life easier potentially. One is, if you're a company, the use of FinCEN identifiers, requiring whoever's your beneficial owner or your company applicant to register and maintain their FinCEN identifier is a way that you can the company can mitigate its risk that occurs when, for example, your CEO moves and forgets to tell you about it. Because, one of the things you'd have an obligation to is update the CEO's address if they moved. And so the use of a FinCEN identifier can, mitigate the burden on the company to have to monitor for those things and place it more on the individual. There's sometimes where, for instance, you have an individual who is, would be a beneficial owner because they own 25% or more of a reporting company, but they own it through another entity that is exempt. So, if that's the case, rather than having to collect that person's information, you have the option to just report that the name of that person who is the name of the entity through which that person owns, the equity interest in the reporting company. I mean, 2 quick clarifications. That's only on the ownership prong of beneficial ownership, which I realize is a misnomer because there's the substantial control prong and then there's the ownership. This is only on the ownership side. So, for instance, if you have an individual that, owns 25% or more through an exempt entity, but is also the CEO of the reporting company, they would still have to be reported because of their, position of substantial control. If you have a complex corporate structure and there's an option to, rather than having each individual reporting company file their own beneficial ownership report, they could, if the report, if the parent company is already filed and has a FinCEN ID, the sub can just report potentially just report the parent's FinCEN ID in lieu of reporting identical beneficial owners across multiple entities. There is an obligation to update, ID. There's an obligation to provide a photocopy of your ID as part of the filing. Has to be valid at the time that it is actually, filed with FinCEN, so you can't have an expired ID. But there's no obligation to provide a new image of the document when you're reissued a license. So, for instance, in Washington, my license expired, I get reissued one, but my name stays the same, my driver's license numbers stayed the same, my address is the same. It's just a new unexpired license. There's no obligation to update your information simply because your ID expired and you got a new one. But if your name changed, if your address changed, if your the number on your driver's license number changed, you'd have an obligation to report that. So some efficiencies, it's the hope is that, FinCEN's hope at least, is that for most entities that are small, that it's not going to be as complicated, but obviously there's some work to be done here. So I know, Ben, you had one last slide on sort of general trends for startups you want to cover.
Yes, I thought this was just, having practiced with startups for a while, I think back to times when people would ask, how long will it take to get our company formed? And we say, well, we'll do it this morning, which we actually still can do. But that was a marked contrast to other jurisdictions, other countries, where it was more like, a bank, know your customer process, who's the owner, give us information. I helped form a company once in the Philippines, and I had to get an apostle notarized at the community center by someone in Seattle that was then sent to the embassy in San Francisco and sent over. And I thought, gosh, this is really, it's a lot of work to set up a company, but we're seeing some of those same trends. The setup itself still remains pretty straightforward, but you have to think now about the CTA when you're doing that. Other things that are happening, and a lot of this is aimed at foreign relationships, not entirely, but for example, CFIUS, the Committee for Foreign Investment in the U.S., it's been around for a long time, since the mid-'70s, I think, but recently it got re-energized, and a lot of it is focused on probably investment. It's notification if you have investment by a foreign person in a U.S. company with critical technology and some other things, right? So you could think of sensitive information if you're following I guess it's TikTok and all, how much information is getting passed between countries. So now CFIUS is used very actively by the U.S. government, and when you're doing a financing, if you have someone who's an outside the U.S. investor, then there's a concern, are they getting access to information or resources by virtue of that investment? Other examples of that are what we call export control. If you have a software license, can you license it to someone outside the U.S., export it? And even if you have someone working on it who's not a U.S. citizen or permanent resident, then that can be viewed as an export under the export control rules. OFAC is kind of a list of viewed bad actors, both in terms of countries and individuals or entities that should not be owners, and there are restrictions on how you interact with those companies or those persons. So it's a change. You're seeing this change over time, and it increases the cost and complexity. I do think there's going to be a simplification. I think there will be for example, with the Corporate Transparency Act, we're already seeing the services that are the right place to handle it, I think, getting geared up to do that. But it's a noteworthy trend from where things were 20 years ago, when you just assumed there wouldn't be a lot of federal regulation or interest in the activities of your early stage or high growth company. There's a question here.
Thank you. I have a question. So if the company is incorporated here in U.S. and everybody that works at the company is here in U.S., but if in the investment, so if we identify, let's say, VCs in Europe that are investing in our company, would that count towards that foreign relationship issue?
So I think people heard the question, but yes, if the company's in the U.S. and you had all U.S. citizens or permanent residents working there wouldn't necessarily be the same export issue, but there still could be CFIUS. There would be a CFIUS examination of investment by a foreign person in the U.S. company. Okay. And so, and then assuming they're not on the OFAC list, and I don't know all the details about when you need to trigger on that list, because we usually don't see that issue. The main issue in that case, I believe, would be CFIUS, the report to determine whether you need to report to the congressional committee that, hey, there's a foreign person taking interest in U.S. business.
Okay, thank you.
I guess I was curious, since this was created to kind of prevent bad actor shell companies, what kind of teeth does this have for non-compliance? I think you mentioned a few, but
So there's potential civil and criminal penalties for violating the CTA. Mm-hmm. So I think I sort of briefly highlighted, but it's up to $10,000 in civil penalties, and potentially up to 2 years in prison for violating the CTA. So, my guess is on the criminal side that it would be a tack on to some other sort of nefarious activity would be the activity that would be focused on.
okay.
But there's civil and criminal penalties. We haven't seen how this is going to play out yet, but that's sort of generally where I'm forecasting where things will go.
Okay, thanks.
And maybe just to tack onto that, Steve, what's the risk in the absence of a nefarious activity? Because I think there will be, to the point that was raised, there's going to be footfalls, right? What's the real risk for a company here that formed and failed to report a change in address for for the CEO, for example, or a change in ownership, I guess, more germane.
Yeah, I mean, I think the enforcement priority is going to be on any violation that is seen as egregious. Again, it's got a willfulness standard on there rather than sort of a negligence standard. And so the focus, willfulness sort of implies, that that's the sort of the intentional outcome of not filing. But, sometimes, take it seriously and be proactive in thinking about this. Okay, if we, kind of like how, when you move, or you, sort of the things that you need to do are like tell your bank, go get a new driver's license, update your driver's license. My recommendation would be to think about these as just sort of what are the basic hygiene things that you need to be thinking about when information changes so that you minimize, these pitfalls.
All right, well, everybody, thank you for your questions, and thanks for joining. And again, a big thanks to Ben and Steve for sharing this information today. A reminder, next week at noon, Katrina Brady, Copyright and Trademark Manager at CoMotion, will present Using Trademarks to Protect Your Business Identity. Sign up today, and thank you again.